This is an interview with Robert Stebbins for the SEC Historical Society's Virtual Museum and Archive on the History of Financial Regulation. Today is April 17th, 2025, and I'm Kenneth Durr. Bob, good to see you today.
Nice to be here.
Um, I appreciate your hanging with me there on some technical difficulties. Um, let's start by going back a little bit. You had a very interesting college career, and I want to touch on it briefly. You went to Central Michigan, right?
Yeah, so I did. I had a football scholarship there, and my parents were divorced. We had four of us in college at the same time, and we had no money. My mother was a social worker for the state of Michigan. So I got admitted to the University of Pennsylvania undergrad. And back then it didn't cost like it costs now, but to us it was still a lot of money. My mom made $30,000 a year, and there were four of us in college. So it was decided I should take this athletic scholarship and play football, which I did. And I still ended up at Penn for grad school and had a great experience undergrad and a great experience at grad school. So it all worked out.
And you were an All-American in football, right?
Academic All American, a little
Oh,
different.
oh, there's a difference.
Yeah.
Okay. Um, and you were a history major. Did you assume you were going into law at some point?
Yeah. Yeah.
Okay.
I dabbled in some economics and some law and history, finance, economics, and anyway, became a history major. Chased the roads for a bit, and it was a good major. I enjoyed it. I always knew I was going to go to law school or get an MBA, one of the two. So.
Okay. Did you get any experience in securities law or corporate law while you were at Penn?
Well, we took classes, right? I took classes. I wasn't sure if I was going to be a litigator or a corporate attorney or what exactly I was going to do. So when I started at Wilkie, I actually started in the litigation group. So I took evidence and classes like that, but I also took tax. I took securities regulation. I took things that were going to allow me to go down either path, depending on what I wanted to do. So, and I thought about being a tax attorney. I thought about being a real estate attorney. I got to the firm. I was working in litigation. I didn't love it. So I said, I want to bounce over and do a rotation in corporate. They were fine with that. And it was a great fit for me. And so in corporate, litigation, I think it's hard at the big firms to get experience right away, get in the courtroom. Nobody wants a first year associate arguing their stuff. But in corporate, it's like they'll give you as much rope as you can hang yourself with right away. Right? You can do the deal. If you can do the whole deal yourself, go for it. And so we were very busy at the time. It was a great experience. I found it very entrepreneurial, and I stayed and loved it. So,
Talk about the kind of work you did or some of the interesting cases, if
so
you can.
cases is the wrong word for me because deals are what I do. I'm a deal.
Deals. There you
So,
go.
yeah. So, but I also go. I speak a lot to boards. At this point, I speak a lot to conferences, a lot of things involving corporate governance. But that was post SEC, pre SEC. Really a deal lawyer. A lot of SEC stuff, a lot of registration statements and IPOs and follow on things, a lot of day to day corporate compliance with the SEC rules, uh, 8Ks, 10Ks, um, the day to day disclosure. The Rule FD had come in while I was practicing, which was a very good rule, one of the best SEC rules, I think. Um, so I did a lot of work representing hedge funds. A lot of work representing private equity funds, a lot of merger work. I met my wife on a hostile takeover, believe it or not. We were co counsel, not on the other side. It's not as bad as it sounds. Yeah, so just deal work, deal work, deal work. That was a fascinating deal. We were representing the Simons, they own the Indiana Pacers, among other things. And Ambeth, my wife, is at Skadden. She's still there. And is an M&A partner at Skadden. And she had Westfield. And Westfield used to own all the retail under they're called Westfield Shopping
Right.
Town malls. And they had all the retail
Malls.
trade
Yeah.
center, among other things. Very big in California. So, and then you had on the other side the Taubman malls, and they had the mall at Short Hills. They had very nice malls. They actually are part of Simon now, but at the time they weren't. And Al Taubman was in jail for price fixing when he was at Sotheby's as CEO. And so he had also, it turned out it was a Michigan company, and Al had donated a lot of money at the University of Michigan and other causes. He used to own a team in the old United States football they called the Michigan Panthers.
Hmm.
Anyway, so not to belabor this too long, but we went into court. We made a hostile tender offer against the company. They owned 30% of the shares. It was a really tough one. The only way to win it was you needed 2/3 vote. The only way to win it really was to have the board fracture, and the board wasn't fracturing. And so we went into court, and they purchased some more shares. We said it was the defenses were illegal, one of those kind of claims. And they purchased enough shares to go over 33 1/3. So they had a total 100% blocking position. But in doing so, they had violated this takeover statute in the state of Michigan. And so we made a claim that they had not provided the proper notice to shareholders or anything else, and we won, and their voting rights were validated. So we looked great. What they had done now was they went to the state legislature. It's the last time it's ever happened in corporate law history. And they asked that they called in favors and got the law overturned. And they made it say something along the lines of, it's illegal to do it individually to violate the statute, but as a group, it's okay. Which of course makes no sense, but it wasn't about making sense. It was about winning. And so then at that point, my wife became a Michigan lobbyist, and she wasn't my wife at the time, and tried to convince the state legislators that they should overturn this decision, which was a fool's errand. It was not going to happen. They were very powerful, and we walked out some very powerful people. The Simons were huge Democratic contributors, so we had the president's wife come out, and Hillary Clinton, and they just said, go home. And so, and it became a Harvard Business School case study called the Mall Brawl, and I met my wife on the deal, and she's still my wife.
Excellent.
Actually ended up in the Simon. Eventually, 20 years later, Taubman was acquired by Simon. The mall business has become a tougher business. It was a great business for a long time, but nowadays with Amazon and everything else, it's a much tougher business. And if you're going to be in the business, you want premium properties. Those are the types of places that people still go to. Premium malls, premium stores, and Taubman had that. So the Simons were correct in what they were trying to do. They just probably needed to bid a little higher. So.
Interesting. I've never heard of the mall brawl, but it sounds like a fun story.
Yeah.
Tell me about working with the SEC during these years. This would have been during the 90s, early 2000s. Talk about your impressions of the commission, some of the folks you worked with, and just generally what the working relationship was like.
I think it was standard. Everyone's afraid of the SEC, of course. When you're a corporate person, you take your obligations very seriously. I'm not a litigator, so they weren't knocking on my door, and there was less day-to-day interaction. But corporation finance was always a pleasure to work with. It's a great group, and you go through the rounds on your registration statements. Probably a little less political than it is now. There was at the time, but I thought it was always a good relationship. I don't have any specific memories of anything out of the ordinary there. It was a standard working relationship that a corporate person would have, which isn't a lot of interaction. You haven't done anything wrong. You're just sending in registration statements. You deal with them. That merger, same thing. Merger filings. If you have a proxy, the other merger stuff, that's more Delaware, right? You're going to have lawsuits and things. So you don't have a huge interaction with them except in connection with the proxy rules and the tender offer rules, which is a great group at the SEC as well. And people do these things called bed bug letters sometimes, and we would do things like that. I actually don't think they're that effective, but 13D filings, things like that, just standard stuff. So nothing out of the ordinary.
Bed bug letters?
Yeah, bed bug letters mean, they're so if you're in a hostile situation, what you tend to do is look at the disclosure of the other side, and you email the SEC and you tell them, or you send a letter in and you say, here's all the deficiencies and why you should come down hard on these people for not making full and fair disclosure about what's happening. And the SEC often will send comments to people, but at the end of the day, it really doesn't change the calculus. I don't think it just, People always do it, but I don't think it's really that effective, to be honest.
Okay.
It's a
Um,
cool name, bed bug letters. Yeah.
you mentioned sort of offhand that you didn't feel like the commission was as political then as it is perhaps now or in recent years. What were the implications of that for your, interactions and just from what you could see of the commission, say in the 90s versus more recently?
I don't have any real basis for that other than I think some of the things that you like environmental in the last 5 years was a big deal, right? There weren't things like that happening, right? Now, there's always been some pendulum swinging back and forth as to, getting things in your shareholder proposals and everything. But I think there were more 5-0 decisions and things like that that used to happen back in the rules. And I think there was probably a little more consensus than nowadays. There's just going to be a lot of 3-2 stuff in the rulemaking. It's not so much in enforcement, some, but it's more in the rules. I think is the difference probably than in the last 30 years.
Okay. Well, let's get you to the commission then. Talk about being approached for general counsel. Was it a big surprise? Was it something maybe you'd heard was in the works?
No, it was a surprise. So Jay and I, Clayton, who was the chair eventually, Jay and I are best friends. Jay was best man at my wedding.
Oh,
So we met on as you mentioned, I used to play football, and I came out to Penn Law, and I didn't know anybody, right? And one of the nice things about being on a football team is, you go into college, sometimes it can be, it's adjustment, making friends, and everything else. Well, you have 100 friends right away, right? That's nice. And I always encourage any young person who's going to school, join a team, join a club, join a fraternity, do something, right? Make friends right away. Get out there, right? Don't be lonely, right? And so I was going to be lonely. I'm going to Penn Law. I was like, how am I going to meet people, right? Well, it turned out they had a rugby team. And I wasn't going to be, I wasn't the greatest college football player, but I was okay. And against Ivy League law students, I was going to be pretty good, right? And I also was like a Division II basketball player. I'm in my high school Hall of Fame for football and basketball. So, and I used to be a high school basketball coach right before this. So they had a basketball league. I was like, again, same concept. Against law students, going to be good, right? Well, Jay loved basketball and he loved rugby. And so that's how we met. And we've been fast friends for forever. And so I'm almost a fourth brother, if you will. He's got 2 other brothers, so there's 3 total. So we were very close, and he had come up to me at some point and said, just so you know, there's some chance I might be appointed as chair of the SEC, and would you consider coming with me as GC? And I said, yeah, I would. Let me think about it. And I talked to my wife, and she was supportive. And so anyway, that's how it all started. And right from the start, it was a great thing to do. I always knew people came up to me once my name got out there, and they said, I had always had a sense the SEC was a pretty great place, and people started coming up to me, and they felt so strongly about the institution, the alumni who'd been there, right? About what a great experience I had and was going to have, and if anybody could be helpful, they were all willing to be helpful. And maybe there's self-interest in that, I don't know, but they were really supportive. And so I sensed it was going to be a great place to work. And when I got there, it even exceeded it. So there you go. It was wonderful.
what did Jay Clayton talk about things he wanted to do, a program he was hoping to implement or just changes, anything like that at the commission?
Well, I think Reg BI was something that was front of mind. I think Jay also, everyone has their own style, right? I think the last 4 years it's been a little bit more top-down driven. Jay was bottom-up driven. So Jay would go out to, he'd meet with the main divisions, and they'd say, well, what is your policy? What do you want to do? What's your platform? He's like, well, what do you want to do? What do you think is important to people, right? And Jay's big thing was he knows markets probably as well as any commissioner or chair they've ever had. And so he wanted to make markets more efficient. Capital formation was going to be a very big thing for him, and that was important. But also, people had other ideas and things they thought were important to do. He would empower people in the division, and the division heads, of course, themselves. And so I think you saw a lot of stuff come out of Bill Hinman's office and Brett Redfern's office, TM and CorpFin, and Dahlia Blass and IM had a lot of ideas. And so I think we were pretty busy from a rules perspective because they each did have a lot of ideas and a lot of things they were important, thought were important to do. And I think you saw the focus of enforcement move toward the Main Street investor, right? Which I think is personally, everyone has their own views. That's where it always should be, right? I mean, I think if you read the stuff, there's a sign when you're in the offices on the 10th floor about the ordinary investor being, job one at the SEC. I think it's from Douglas about protecting them. And that is still, to me, the number one job, right? So enforcement was geared more toward the Main Street investor than perhaps it has been in some other times. And I think that if I was to guess where it's going to go back to under Paul Atkins, I'd say right there. It's going to go back to the protecting the Main Street investor, which is, to me, the right place to be. So anyway, that's a long rambling answer of like, I don't know that he discussed with me exactly, other than, what his main theses were as to people, the Main Street part in Reg VI, and then the other stuff just kind of evolved.
Okay. Something about the Main Street investor thing. He did kind of a roadshow early on, going around talking to people. Did he do the cities where the regional offices were, or how did that work?
Say that again.
Early on, Jay went and did sort of a road show, talking to people. I know he went to Atlanta, did a big program, talking to Main Street investors and
Yeah.
about Main Street. And were you involved in that? Did he bring people along, or how did that work?
I wasn't involved. Someone's got to run the building, right? Now he would, actually the Atlanta time they actually they took all the commissioners, right? It's never happens, right? Everybody went and they had a meeting down there. But he did 6 or 7 of those town halls in general. I think they're a pretty good idea. They did one in Proxy when I was there. They recently are doing them on crypto and other things in the building these days. But it was a good thing to do. I mean, Jay was just trying to hear from ordinary people as to, what would be important to them if they're making an investment decision. What did they need to know? What did they need to hear? And I think at the end of the day, I think it ended up in a really good place. It's shown, history has shown, I think, right? Where it ended, it's been hard to get TM and IM to work together to get this thing out the door because, one of them traditionally had the BDs and the other had the investment advisors, and they had to come to a middle ground as to how they were going to be regulated together. So it was a little bit challenging in the building, but we did it. And there was some outside pressure. Some people wanted to have just one uniform style or standard, which we thought was going to decrease choice. We thought it was handy to have the broker dealers survive as well as the investment advisors survive. And some people did not agree with that decision, but we thought it was the right decision. And I think if you read the standards, they're pretty close, right? As to one's a fiduciary and the other says that's the investment advisors. And the other, it says you can't put your interests ahead of the investor. If you're the broker can't put your interests ahead of the investor, which is basically this close to fiduciary. So I think there's not a lot of air between the two, and it does allow for choice in both models to survive, which I think is a good thing. I mean, if you're someone who's just going to be in a S&P 500 fund, right? Why do you need to pay 2% every quarter? It makes no sense, right? If you're going to make one trade and go into it, you should use a broker dealer and pay $5 or pay $0 and go into the S&P fund for Vanguard or whoever it is. And that's the way to do it. Eliminating that and making someone pay 2% every quarter, that makes no sense to me, right? So I think it ended up in a good place at protecting the individual investor, which is obviously, as I said, what we wanted to do. So
Okay, so we're talking about Reg BI here, right?
exactly.
Tell me where that.
If you were to look back at the number one rule thing that we did, I think it'd be that one.
Where did that start from? How did that get generated?
Well, it went on for decades, right? And there had been talk, as I rambled on there, about the uniform standard that people wanted to, there had been some commentators suggesting there should be a uniform standard. And the fact that broker dealers had a suitability standard, which was too low, and compared to the fiduciary standard that was the investment advisors were held to based on the court decision, that they ought to be uniform, and that broker-dealer standard needed to be raised. Well, we did raise it, but we didn't make it uniform because raising it would basically eliminate them, and you just have a bunch of investment advisors. So we thought it was best to keep choice. And so we ended up acting based on the Dodd-Frank Act. There's a bunch of stuff that happened in the Dodd-Frank Act in 2010, where the SEC was told to do a study on these issues, as well as given some empowerments. And we did, we acted under it. And there were some lawsuits that later came out of that, basically saying that we were actually, people were arguing that we were forced to have a uniform standard. And we totally disagreed, and we won in court. So that's kind of the history of it. It comes out of Dodd-Frank, but nothing really happens for a while, other than probably infighting in the SEC. So we started conducting these studies, and that did happen, but nothing had happened as to actually formulating a rule. So, we got there and we acted on it and managed to make it happen. And it was probably job one for Jay at that point. We talked about going around and doing these town halls and having 6,000 letters, and every one of which needs to be addressed. And it was a big deal. So, and I think it's going to last. It's a good thing.
Talk about working with IM and trading and markets, bringing them together during this rulemaking process.
Yeah, the key is having the heads of the place get along and want to do this, and they did. So Brett Redfern is TM and Dahlia Blass is IM, and they both, I think, understood that this was very important to Jay and very important to the investor community and something that needed to get done. So it wasn't simple. I think the people underneath them, there had been, there's a lot of, you own the BDs and somebody else owns the IMs. Owns is the wrong word, but in charge of supervising and regulating. And, you're looking out for their interests and being careful. And so just coming together as to how this was going to work was always challenging. But, Jay's a good leader, and there's a lot of, he understands the issues that come out of this, and he did a good job. So it was nice. It was great to get this done.
Characterize how the process works. Generally speaking, in these rulemakings, did you have the divisions sort of draw something up and get together on it and then bring it to you, or how did that work?
My office, the GC office, one of the great things about the GC office, it's involved in everything, especially when my relationship with Jay, I'm really involved in everything. But so the rule writing happens in one of the 4 groups in the office of the general counsel, and Meredith Mitchell leads a group, she's still there, that does a great job, and she works extremely hard. It's a pretty lean group. They don't have a ton of people, but she has a person who specializes in IM, one who specializes in TM, one who specializes in Corp Fin, Brian Morris, and they all, depending where it is, they work with the division as to drafting it, right? So they're not drafting it per se. The division is doing the first draft. And this one, they're both divisions are involved, together getting the first draft. And then Meredith is working on the drafts. I don't see the drafts till pretty much farther along in the process, right? Because they're making sure it follows precedent, that every comment that comes in is being addressed, and it's quite a process, especially when you get 6,000 letters.
That's what you got on Reg BI?
Pretty sure we did. Yeah, which is a lot, right? I mean, they all get responded to, so that's a lot of letters.
Yeah, a lot of mail to read. So it sounds like the general counsel's office is sort of working alongside the divisions.
It's true.
Yeah.
And we work very close also with enforcement. So Laura, when I was there, Laura just left, her Cassie, but she was great, and she worked every week with enforcement. People to understand that every week we see 5 to 10 enforcement cases, and they tend to be ways where the cases in which the average investor is getting hurt, right? Not always, but generally there's pump and dumps and other frauds that are getting pulled and on a daily basis. It seems to be happening, and there's a lot of recidivism. It's hard to stop it. At the end of the day, we don't carry guns. even though you've seen the movie Wall Street, and we look like we do. We don't have criminal authority. Can't people put people in jail, and we work with the U.S. Attorney's Office pretty closely. But if something's what they would consider not a very big case, they're unlikely to want to get involved, and thus these people tend to, you give them a fine, they don't pay it, right? And then they change their name and they do it again and do it again and do it again. And you give them these bars that say conduct bars that you're not going to do this again, and they ignore them. And so, really, the only way to sometimes to get lasting relief on this kind of world is to have the Justice Department involved in the threats of jail. That's the most effective thing. Fines, they work against corporate America, right? We're very powerful against them, but it's hard against protecting the average investor. We do our best. We try. People really try hard. They really care about the mission, care about protecting these people. But it's never simple. And we work every week on the enforcement calendar. Now, Jay would be very concerned about not taking what he would view as overly aggressive positions. He wouldn't like to see us taking positions that we think create a lot of litigation risk for the institution. We never thought it was helpful to be losing in the courts, right? So, and there's plenty of authority, and you can really protect yourself based on, 10b-5, Section 17. You have a lot of power. You don't need to go convert books and records charges into something more substantive. That doesn't need to happen. It wasn't something we were going to do, and so that was our mandate, the way we were viewing it. And so people at the SEC and in my office would make sure that those positions weren't being taken while we were there.
So in some respects, you probably had a restraining effect on enforcement, let's say.
I think so, right? I mean, it's not. I mean, there was still plenty of enforcement every week. There was 5 or 10 cases, but as do some charges, we weren't going to bring those under some theory.
Okay, so I guess nothing that would break new political path, or not political, but new legal paths, new novel litigation.
That's right. That's a good way to put it. No novel theories.
Okay. Right? Were there any notable enforcement cases that you worked on, things that lasted a long time, consumed a lot of resources?
I think you're always concerned as to how long these things take, right? I think if I was to give a criticism of the process, I would say, and I always was trying to make sure my people were aware of this. The way the rules were set up is, and I don't know what's happened on the recent court decisions, you had to exhaust your administrative remedies before you could go into court, basically, right? And so what would happen is, you see these situations where we would bring a claim, let's say it was brought in the administrative courts, and then it gets appealed to the commission, and then it gets appealed to a district court or a circuit court, and then it gets sent back to the SEC, and then it goes back and through the process again. And so this can take 5, 10 years, right? And it's expensive. Hiring me is expensive, right? And to do these things, right? And so the average person can't afford this, right? And so you want justice for everybody, right? You don't want it to be where you have to settle this because you can't afford the fight, right? And so we were always cognizant of that when I was there. And I know Commissioner Peirce is to try to get these things happening quickly. So the longer these things drag on, the higher the legal bills are, right? Even if it's not going through years of process, even if it's 2 or 3 years, it's still very expensive, right? So that would be something we were always aware of. And as to specific cases, I mean, obviously the Musk case got a lot of air time. I actually thought that was a pretty good resolution at the end of the day. We let the market decide things as opposed to us kind of deciding what was going to happen. I know there was a case against a congressman for insider trading. Those are always politically very sensitive. I don't think he's a congressman anymore. I think it was insider trading, happened on the White House lawn. Yeah, I mean, there's always interesting stuff going on in these cases. Insider trading ones, the law is a little muddled. I think it could be better, but those are always good ones. I think it's those are we're very good at finding it. When it happens from forest jurisdictions, it's sometimes tricky for us, right? Um, People aren't extraditing, except for the Canadians and maybe the British. People aren't extraditing people, right? So things that happen offshore are very tricky. But those are always, I thought, to be very interesting cases. And yeah,
You mentioned the Musk case and letting the market decide. Explain that a little bit.
well, at the end of the day, we tried to empower the board more, and we tried to change who was on the board. So it was a more, in our view, independent board. And so Larry Ellison came on the board in replacement of his personal lawyer, among other things, right? And then he had, he had things with the court where he was having to clear things. Now, I don't know how effective that's been. I know there's been people upset that he hasn't cleared everything or at the time didn't. But anyway, we thought it was a good result at the end of the day rather than banning him from the industry or going after him for a large fine or something. I think that was a better way to do it. Let the board get the board involved, and I think at the end of the day, I know he hasn't necessarily been happy with how it played out, but I actually thought it was a pretty good decision, pretty good resolution.
Okay. I read somewhere that the rulemaking agenda when you came in was historically high, or the number of rulemakings you had to do. What was the cause of that? Was that Dodd-Frank still hanging on, or what else?
There were some that had to be finished, and I know that even now, Chair Gensler was finishing some, and we thought we were very busy. I think he might have even been busier. Um, but I just think there was a lot of stuff that Jay wanted to do, and the division heads wanted to do, and we talked about BI, but there was a lot of other technical rules that we thought made sense to modernize the markets, especially in TM. Bill Hinman had a lot of ideas as to things that to modern. These are both all people who practiced, right? Which I personally think is really important, right? Having people who practice in the space. So Bill was a great securities lawyer at Simpson Thacher, and so he understood markets. He understood what potential rule changes would be helpful for capital formation, which is one of the three prongs of the mission, right? And I'm in the city bar, and I was talking to people, and I said, well, one way you could be helpful, you understand how things work. Think about what changes you would recommend to Paul Atkins to make capital raising more efficient. You always have to understand we still have to protect the individual investor. So it can't be just like everyone do whatever they want. But think about, smart technical and substantive changes that you think would allow for capital formation to be more successful. I think you're going to see things nowadays. I think you're going to see changes to the accredited investor standard, as well as some other things. I mean, I think Chair Clayton is going around saying he thinks taking the Reg A exemption annually to $1 billion. Anything, there's a lot of interesting things people are thinking about. So I know back then, Bill had ideas. Brett Redfern had ideas as to how to make the market quicker, more efficient. Markets are always evolving, right? We've always had the situation where you have big players in the market like Virtu, like Citadel, how to make sure everything's fair, right? High speed trading, et cetera, right? And I know Dahlia had a lot of changes she wanted to make as well. So, and she did. So that just turned out to be a lot of rules, very busy, but that was good.
It sounds like these rules were matters of adjustment rather than big programmatic changes.
I think the biggest one was BI. Other than that, I think they were just, evolving markets, and
Okay,
it wasn't something like the environmental rule or anything like that. No.
right. Um, Before we go further, let's talk about how the office looked. I'm thinking there were about 150 people there, something like that.
Yeah, yeah, that's about right.
How was it divided up? What were the groups?
So four big groups. You had Appellate, run by Michael Conley at the time. He just retired. Amazing lawyer, probably my right-hand man, if you would, during everything. Just a man always involved in everything in the building, a real institutionalist. I think you've spoken to him before. Just a fantastic person, a fantastic lawyer. Had a great feel for what's important, and we see the world a little differently, but we're really close. We're great friends. And I talked to him, to go through some of the cases again to remind myself. I talked to Michael in preparation for this. So he was awesome. And so it's a really prestigious, great group. People who could work anywhere but choose to do this. And at the commission, really, they're fantastic. They get all the cases, all the ruled cases, into the circuit courts. They also work with the Supreme Court on the Supreme Court cases with the Office of Solicitor General. They work very closely with the Justice Department on appeals, civil justice. So it's quite a great group. We also had something that was run by Jeff Fennell, who's the acting GC at the moment. Jeff used to be my office mate at Wilkie and then became a career SEC person in enforcement. So I brought him up to the office when I came in to be GC, and Jeff ran what we call adjudication. And Jeff had a pretty remarkable record of 50 or so adjudication matters, all unanimous, and try to do that sometime with the politics of DC, right? Pretty hard. So pretty impressive, I thought.
Is this the administrative law group, the adjudication?
I think these are the people who would do the appeals from, FINRA, these kind of things, right?
Okay.
So it wouldn't be, it's not the enforcement appeals of, the cases we're bringing from front of the ALJs. It's a little different, right?
Okay.
Then there's general litigation, and it's almost like the GC's office at a law firm or at a company. So they handle, the employee issues in the building, labor relations in the union contract, leasing of the office space. They also do some attorney discipline. They do everything, right? So everything else is this group.
What was the name of that group?
It's called, I think people just call it general litigation. They have names, legal policy 1 and legal policy 2, but there's no reason to use those. So Michael always called it general litigation. Legal policies, the rulemaking stuff is generally how we think about it. They also, Laura Jarsulik was the person working with enforcement. She's in that group on a weekly basis. She would always work with them on the calendar. And then there's somebody in that group who also does legislative affairs, but that's just where it is. So adjudication, that's finale, right? That's the litigated administrative proceedings, which they're not doing a lot of anymore. Those have kind of stopped. They still have some things they need to do, but those are generally technical at this point. So they would do those, and the appeals from the SROs, the self-regulatory agencies, and the disciplinary stuff that FINRA and others would do, they would hit those. So there's a fair amount of those appeals. So they were busy, and they have to write an opinion on each of those and work with the commissioners on the opinion, and then the commissioners would sign on or not, and they'd adjust the opinion. And so they would negotiate the opinion. That's how you get 50 unanimous decisions.
You said there were 4 groups. What was the 4th?
The legal policy is the rulemaking, right? General litigation is the stuff that Jeff Rosenblum ran it when I was there, and then it changed near the end. So that's matters ranging from employment, the people in the building, labor relations, anything that happens with an employee, right? It's like the group in a company. It's be like the GC's office at Revlon or whatever your company is, right? So the legal policy, rulemaking, the general litigation, the people in the building, appellate, which is Michael Conley, and then adjudication are the people dealing with the administrative proceedings and the appeals from the SRO. So those 4.
And you talked about writing opinions. How closely did you work with the legal policy people for that?
So legal policy is the rulemaking. So I would look at the rules. I would always read the rules. And Michael Conley and the appellate team is always involved in the rulemaking because they all get sued under, right? Every rule gets challenged, even back then. And so he's looking at things to make sure because he knows he's going to have to defend it in court. He's trying to position it in a way that's defensible, right? And they're also making sure that we've addressed all the comments, so we're not failing to comply with the Administrative Procedures Act. So we're all reading it, and I read it. I read every rule, important rule at least as well, and then I also would read the opinions. I mean, they do such a good job, the briefs, not the complaints, but the briefs that would be put together in the Supreme Court and the appellate court actions. I would read those. They'd all get sent to me. I tend to try not to have a pretty light pen on those because I'm not a litigator, and I've got Michael Connolly, who's the best, looking at things as well. But also you've got the Solicitor General's office, you've got the Justice Department. There's a lot of people to pen. So I tried to have generally pretty light comments and let my people do their thing, and they're pretty good.
When you're taking opinions to the commission, were you ever in the position where you're really trying to sell something to the commission, or did you really let them stand on their merits and explain
There were
them?
some, right? You try to go around and get more votes on things, right? The Commissioner Lee, Commissioner Jackson at the time, right? And you go talk to them about where you're going to end up on something, and the positions of the chair. That was also done by the Chief of Staff, by Lucas Moskowitz and Sean Memon. They would also go out and try to talk to them and sell things, right? So my job is to represent the building, right? So it's not so much for me to go do that. Sometimes I go there and have to talk about ramifications, and I would often take Michael with me, and sometimes people agreed and sometimes they disagreed, and for various reasons. That's what they're entitled to do that as commissioners, right? So they talk about the GC position on these things. They want to make, sometimes people question whether it's a permissible thing, and we were not taking any stances that we thought were impermissible. So, and Jay was great that way. Everybody has different views as to how involved the GC's office should be. We were probably as involved when Jay was there as we've ever been. Michael was very valued. Obviously, my relationships with Jay. So we were really involved. And Jay did not want to lose court cases, as I mentioned. So we lost some. When you show up, it doesn't take 1 year for these cases, right? So we lost a couple in the beginning. These things have been old and cold, showing up on our plates right when we walked in. But I think if you look at our record, near the end of the term on the matters that started when we were there, I think it's pretty good.
I want to get into those cases, but first I want to just clarify something. You used a phrase I'd never heard, which is your job was to represent the building.
Well, I'm in charge. I represent the SEC, right? I mean, I'm just Jay's lawyer. I'm everyone's lawyer, right? I mean, represent all the commissioners. I mean, I don't really represent them per se, but I represent the SEC. I'm the SEC's general counsel, right?
Okay.
So I view it.
Okay, great. Well, let's get into
We have
some.
a special relationship with them. At the same time, I understand my obligations.
Oh, how about amicus program? At various times, the general counsel's office has been had different degrees of activity in that area. Did you have a strong amicus program when you were there?
I think I would call it a standard one. I don't think it was one where we were trying to, direct people in certain ways. I think that happened maybe the last time that happened is when they did some of the reforms to try to have less class action, some of those things, the private security litigation releases, and I think there was a little amorphous as Congress can be sometimes. So we were trying to fill in the blanks, I think, at the SEC back then, at least the view from Michael is, and then go around and, looking for cases to bring an amicus in, to file one in, to try to guide behavior, to let you know how the SEC was viewing this at least. That really wasn't our, we had, I would call it a standard amicus, time. It wasn't like we were out there looking for cases to write amicus briefs on. It happens. Judges ask for our views, but it wasn't something we were actively out in. And I talked to Michael about this. His view is he would call it historically a pretty standard time for amicus briefs.
Okay. Well, let's talk about cases. The first one on my list was the Gentile case. Gentile
Yeah, I
person?
mean, I think Gentile.
Gentile.
Yeah, and I think just Gentile. I had some notes. Um, Let me just do Gentile up. That's the injunction case, right?
Yep.
Yeah. So I think that one kind of comes out of. I don't think you can talk about that one without talking about Kokesh, right? And Lou, right? So I think you need to start there in some way.
Great. Let's start with Kokesh then.
So Kokesh was the 2017 case, and I talked about that's when we started, right? So this is one that was in the works for a long time before we showed up, and it was in the Supreme Court, and they basically held that it was a disgorgement case, and the FCC remedies the FCC has a lot of remedies, potential remedies, and people were concerned after this defeat in the Supreme Court, it was really going to affect things. I don't think it has that much, but basically, so disgorgement was determined to be a penalty within this provision of the U.S. Code 2462, and thus anything that's a penalty under this provision of the code has a 5-year statute of limitations. So thus, when the claim accrues, the penalty needs to happen and be issued within 5 years. You would think that's plenty of time, right? But sometimes these things drag on, right? I think there was a lot of back and forth in the building on this one because certain commissioners would be very interested in having, what we're arguing, what we're going to argue, because the idea that there can be 10 years you're out there and you're still not at the statute of limitations, some commission would be like, what's going on here, right? This is too long, right? So anyway, we argued and lost, and basically, and then the other cases kind of flow out of that because the court didn't determine, they basically had a footnote that said, we're not opining on whether disgorgement's a permissible remedy at all. And so people immediately started bringing these claims that it's not just that it's not okay after 5 years. You can't bring it at all, right? And that is the Lou case, right?
Right.
It's a case that we won. And that happened later in our term because these cases started happening right after Kokesh got brought in 17. So you started to see all these claims, and then it worked its way up to the court. And then we won that case 8-1, which was a nice victory.
What was the difference?
Well, the court just determined that disgorgement was okay. They put some parameters on it. I mean, I would say, was it 100% victory? No. It was somewhere in the middle. We still won. We're still able to have disgorgement, but there were a couple requirements of it. Number one, if it was like a total fraud, this doesn't apply. But if it was like a real enterprise and things went wrong, and there was some disclosure claims or whatever it was a net number at the end of the day. If you had expenses, you could deduct those from what your disgorgement was going to be. So net profits had to be disgorged, and where they were going to go. So it was determined that they needed to go back to investors. Since this is supposed to be equitable and not a penalty, it needed to go back to investors, the money. And so you had to make an effort to return the money. Now, sometimes you can't do it. You can't find anybody, right? It's not possible. At that point, the court didn't really say what would happen, but I think the courts have generally understood that sometimes it just is going to go back into the budget of the SEC. There's nowhere else to go with it, right? But you do have to make a strong effort to try to return the money to people, right? And if it's not much money, then, do you have to spend $1 million to hand people back $10? I don't know that you do, but so that's a case that's sitting out there. And then Gentile falls into, comes next, and that's a Third Circuit case, and it's again disgorgement and whether, or not disgorgement, but statute of limitations and whether that same provision of the code 2462 applies to injunction and whether those are penalties. And so it's basically the Kokesh decision again, and we won that one. So it was determined that injunctions are not penalties. They're not used they're to prevent the future wrongdoing as opposed to deterring people and slapping people from their actions in the past. And so we talked about the injunctions that the SEC likes to bring, and they're like, you're not going to violate the law anymore, things like that. And so it was determined that those were still okay. You see a ton of them in SEC actions. I don't know that it's really that they're turn out to be so important, but they do lop them in there. And so anyway, we won that case. It was determined that they're forestalling future violations rather than punishing past wrongdoing, and thus they're not penalties, and thus they were okay.
So once those cases went through, was the SEC in sort of a different territory? Had that changed the ground in any way?
I mean, I think once we won all these cases, I think it was fine. I mean, you have to adjust your damage stuff a little bit, but it wasn't that hard. We can still have a disgorgement, right? There's a statute of limitations that applies to it. That doesn't sound crazy to me, right? I mean, 5 years is a pretty long time period. It gets enforcement moving. And then you can still have your injunctions. If you're going to have the if you're going to have disgorgement, you have to do the net profit thing, and you have to try to have the money back. These aren't like crazy ideas, right? So I think it's very workable. So did we have to make adjustments? Yes. Were these a big deal? I personally don't feel like they were. There were a lot of articles written, but I think they worked out just fine.
How much did you how often did you work with Michael Conley on this stuff? Did you talk to him every day?
Michael sat right next to me. We talk every day.
Okay.
Not necessarily on this particular stuff, but on stuff every single day. Yeah.
Okay.
He's a great, I mean, Michael Conley, in my view, is the best employee in the federal government until he retired. He could go monetize for millions of dollars. He chooses not to. He doesn't care. He's a great employee of the SEC, as good as there's ever been.
Great. Anything else we should talk about in terms of cases?
Yeah, I think the other cases are the cases, relating to, the Lucia kind of Jerkesi stuff, right? Those are the other ones I think are pretty interesting, right, as to where those are going.
Yeah, talk about Lucia.
Yeah, so that was an interesting one because, we were involved with the whole federal government and trying to figure out what to do. And I think a lot of the people didn't like the idea of these administrative proceedings happening outside the court. And I think it actually, in my view, was at least a mistake in some of the cases the SEC brought in there. And I think Michael agrees with that. And that started to happen around 2014. And the cases that you still see winding through the court were brought from like 2014 to when we showed up, right? Back, the SEC didn't really have the ability to go into the internal courts and look for civil penalties. It wasn't allowed. And then it changed to Dodd-Frank. And then nothing still happened, right? But around 2014, they started to use them. And that was where the mistake was. So when you're going to do, it doesn't, I actually felt like the courts were pretty fair, to be honest. Yeah. But I thought the perception wasn't good, right? The idea that you're making determinations of people's credibility and making you be able to lob big penalties in an interior court is not a great look, right? And so I think that was a mistake, and I think this mistake has been rectified, but there's been a lot of court cases that have come out of the mistake. And when you started bringing these cases against people that had resources, people from hedge funds like Lucia, he can fight back, and he did.
Right. Okay, so it's the judge, jury, and executioner thing, I guess. But just clarify for me. I mean, the ALJs have been there for quite some time. What was the mistake in 2014?
Start bringing cases, the civil penalty, insider trading type of cases in those courts, as opposed to the more procedural cases, default judgments, things like that. Those efficiency-wise make all the sense in the world to do through there. Something like, where we can fine you $100 million, and that those do not belong in those courts, in my view. We stopped bringing them in those courts, and I think it was a mistake to bring them, and I think those cases all came out of there, and they still are. The ramifications are still being felt in the federal government. The Lucia case was an SEC case. We brought in the Solicitor General did not, they're very good at picking the winning side, and they knew we were going to lose. We still fought it and defended the case, but we had to bring in, they appointed somebody, the judge appointed somebody, one of his former clerks, Roberts, to take our position. The SG was on the other side, which meant we were going to lose, and we did. It was, the SG's office was very concerned about the case because we have three at the time, three, and you can have up to five, I think, when we were there, but three ALJs. Social Security is 1,400. And so if you took all of those cases and moved them into an Article 3 court, it would not be good, right? I mean, it's a real issue for the Article 3 courts. They can't afford to do that. So you had to do something that was not going to knock out those cases from the perspective of the ALJs of Social Security and maybe a couple other agencies, but would still address the SEC cases. And so that was their concern as to how these were going to play out. And at the end of the day, the court found that the ALJs were constitutional officers. This kind of comes out of the earlier cases related to the commissioners of the PCAOB cases. And that was before we showed up, but they find that the ALJs are indeed constitutional officers, and they were appointed incorrectly. And that's easy enough to fix, right? You can just go appoint them and then have a new hearing. But there's another issue, which was removal. And the court did not address. We asked them to address it, and they did not get to it. So that was then going to be sitting out there as an issue as to, after the PCAOB case, how many layers of removal protection are you allowed to have from the president? And the answer was one. And so the ALJs had more than one, right? So that was always going to be a problem, right? They had the Merit Protection Board. They had like 2.5, right? And so we had arguments as to why it was still okay, but we knew it was a risk. And then Cherkasy happens, and those cases had to work their way out, and they happened after we left, the end result. But, Cherkasy was happening while we were there, but it doesn't get to the Supreme Court until later. And it was basically found that, again, the removal protections were not okay. And so it finally got addressed. Now, and it got decided on like a Seventh Amendment ground, jury trial right up at the Supreme Court level. People still would have the ability at this point to make a constitutional claim, which they didn't get to say that the ALJ process in general is illegal under the Constitution because of removal issues. They didn't deal with that at the Supreme Court level. So there is some risk that the SEC still has for these kind of anything happen at the ALJ level. But as long as it's default judgments and things like that, I don't think there's much risk. But if you actually started bringing these cases again, there'd be a lot of risk, right? So I don't think you'll ever see those things happen again.
Okay. Any other cases we should talk about? I'm glad you brought those ones up.
No, I think those are the main ones. It was very interesting to watch it happen, right? I mean, Health and Human Services had 60 ALJs, and I want to say they had a backlog of like 100,000 cases, right? So the idea, same concept. I mean, you can't just go toss those on the courts. I thought Sotomayor's dissent in the Cherkasy case was interesting because she was positing that there's a number of agencies that have the ability to. The way the court decided it was they talked about an exception if all you were doing in the removal cases was public benefits, which is like the Social Security cases. It's okay. You don't have the right to a jury trial. But if it's penalties, you do, right? And so Sotomayor mentioned another 15 agencies and said all of these have the ability to do penalties. Now, the question is, are they doing it? And do they really? Some of them don't even have ALJ, so it's kind of theoretical, I think. But it's still an issue that's sitting out there still for the federal government. But I don't think it's necessarily a very real issue. I haven't heard anything. I think things are still working just fine. I think these cases came out in a good spot. As usually the court's pretty thoughtful, and I think that it's working, which is good.
Okay. What was it like managing the office during COVID?
Uh, it was challenging. We were, as you might know, we were the first agency to shut down, I think. We had some cases. It turned out the case that started it, this all at the SEC, someone who actually didn't end up having it. But, people were very concerned. We were very concerned, tracing back. As you might remember, it was a very challenging time figuring out really, you know, how close you could be to somebody, how far back they were contagious. And so this person had gone to a doctor and they had said, we think you have COVID, which he did not have. But we were very concerned that he did. And so we started to look back where the person was, telling other people, and people were very concerned, understandably. And so we basically shut down floors. And then another case happened, and Jay just said, you know what, they're going to keep happening. We're just closing the building. Right? And so he did. And there was maybe 10 of us that still came in. The markets people still have to deal with the markets, right? So TM, there was a bigger group. But other than that, it was just going to be division heads. And everyone else gets to have to work remotely. So it's a real challenge for the tech people, but they did a great job, right? And tech at the SEC is challenging because let's say somebody gave me numbers once, like JP Morgan has a tech budget of 6 billion and ours is 6 million or something like that. So it's hard to get the same people, right? I mean, we can't pay them as much, but we still had good people, and they did a good job getting everybody working remotely, and we still functioned, and we were proud of it. So,
What
we
kind of work?
still drove down every week. I commuted for 4 years every week, and so we started driving instead of training. It was the only difference for us. And you'd walk down the streets, there's nobody on the street. That was different. I mean, the lights are off in Congress. That was different. But but it was good.
What kinds of work lent themselves to working remotely, and what were some of the things where people really needed to uh, be in the office, or where you had to make special arrangements for working remotely?
Yeah, the court cases are tricky, right? I don't think it's as effective when you're having to argue remotely, right? You want to be in the building, right? So those were always challenging. And technologically, some of the places, we had some concerns about some of the technologies. We were good with some systems and not others. But some of the courts would flip flop that, right? Vice versa. So we had to have the ability to special computers, to not, like, I think it was actually, they were concerned with some of the data being scraped into China, right? To call it instead of what it was. So they had special computers that you could, and systems that you could do video stuff just in courtrooms, and it was just limited just to that, right? So that was the only data that you weren't in the system otherwise. So that was always challenging. And litigation's a big part of what we do, right, in that group. So that was going to be tougher. Just having the meetings is tough, right? Not having everyone in the same room at the commission meetings is tough. Not having everybody in the office when every Monday, Jay would have a meeting of everyone, all his 30 division heads or division and office heads, and they're not all there, right? And so you lose energy in the building. I don't think it's as effective a place, but we still did a nice job. I think TM's the other part of people, they need to show up some because they're regulated in the market. So some of those people had to show up, and they did. And we just had to try to protect them, make sure they're safe.
Were you still on lockdown when you left, or had you changed back?
I don't remember, to be honest. I left in 21. I don't
Yeah.
remember.
Okay.
I mean, I think things started to get better with the vaccines out in 20. I think they were, in the summer of 20. I think things started to get better. Yeah. But, they didn't come back to the office until like a couple months ago, right? So they
Right.
only come in once twice, 2 days every 2 weeks, I think. So, yeah.
Okay. Um, Something really interesting is your work in the CARES Act.
Yeah.
And you were like something like detailed to the Treasury. Tell me how that worked.
So the Treasurer General Counsel's a friend of mine, Brent McIntosh at the time. He's now the Citibank GC and close friend. And then he became Deputy Treasury Secretary, uh, the Undersecretary for International, I think his name. But remember, it's COVID, right? So nobody can travel. So there's nowhere to go. So he's doing it all remotely. And then this liquidity crisis happens. And this was the first, Trump's sending money out to everyone to try to keep the economy going here with COVID. And so everything is getting funneled through the SBA, and they're making these loans with the banks. And, that was pretty well done, I think, right, to be honest, to get all that money out there that quickly. And yes, there was going to be fraud. That was just how you accepted that, because you had to save the economy, and save, people needed money, they needed jobs, they needed to work. So we, a lot of money got sent out, and one of the areas of focus were the planes, because no one was flying, right, and saving the airlines, right. We still wanted an airline industry, and so I was sent over there to try to help, and I did my day job as well, and so I would still help out, and they're doing kind of private equity deals where they're trying to get paid back, get some equity in the company for doing this. And so these are things that this is my world. This is what I do. I mean, you just have the documents, drafting, and everything else. So I could be helpful. And so they had a great team anyway. I don't know how helpful I was, but I go over there and made suggestions and read documents and drafts. And they used documents from earlier deals from the '05 meltdown, the financial sector. So when the government was taking equity in Goldman Sachs and places like that. So those documents were used, and warrants and all the rest. So we're kind of right up my alley. So I just did both jobs.
Okay. So you were essentially working on the deals that would save the airlines.
Yeah.
Okay. How long did that last? Was that like a few weeks, a few months?
Yeah. Yeah. It went pretty quick.
Okay.
It had to. They needed the money, or they were going to be bankrupt.
Right.
They're saying we can't make payroll. I mean, all the CEOs, remember, came to Washington. And, I thought Treasury did a great job. The country came together. It was nice.
I've talked to a lot of people about the SEC's adapting to cybersecurity, and I was surprised to see that you did an operational review, some kind of investigation regarding a breach of Edgar.
Yeah. So the breach happened before we were there, but we were alerted to it by, I think, the FBI. And so Jay was always a big believer in eating your own cooking. So we had a breach, we were expecting corporate America to disclose a breach like this. We were going to disclose a breach like this. We did. And then, of course, Congress got very interested very quickly. So Jay delegated to the Office of the General Counsel the investigation. And so we had also some people in enforcement helping. A guy who ran the Boston office at the time led it together with Jeff Fennell, who's the current, from my group, who's the current head of the office. He's the acting GC. So anyway, it was a great investigation. They did a great job, and they sat there and testified to the committees. I was there, to committees, the congressional committees. I think there was more staffers than the committees themselves, but told them what we were doing, told them our, the results of our investigations, and it was good.
What did you find?
We found that there was this is kind of state actors that people had been in the inside in the Edgar system, and the way that they were doing it was pretty sophisticated. So they definitely made some money on this. We brought charges against people, the type of charges. We think it's important to bring them, but nothing's going to happen. People aren't extraditing people from Russia, right? But it was really Ukrainian. There were some U.S. people, people from Russia, from the Ukraine, and they got in the system, and they weren't in all of the system, but they were in Edgar, and they would look at the test filings, and if people didn't use dummy data, they say, here's what my quarter is, and they used real data. Then they could see the numbers before they were announced to the street. And they had to be sophisticated enough to know how the street was going to react to the numbers, right? Because if it's just going to be, oh, that's the standard quarter, the stock's not going to move. But they had to know that it was either a great quarter or a bad quarter, and then the stock was going to move one way or the other. They could get on the other side of the trade. They made a lot of money doing it, so it was pretty sophisticated. And anyway, that was the Edgar hack.
An internal investigation like this, was this something that there was already there was kind of a formula or a procedure that you just pulled out of the closet, or did you kind of create this thing new?
I think we created it new, but I mean, we have people. This is kind of what we do. We have people who, Paul used to work at the U.S. Attorney's Office in Boston, and we're used to, these are people who are used to investigating, things, right? Whether we're given a tip, we talk to people, we take testimony, we look into things. This is 101 what we do in enforcement. So we're going to be good at it, and we were.
Right. Cybersecurity in general, were the rules in place at that time sufficient to protect investors, or did that continue to be an area of interest for the commission?
So I think it's an area. It's been an area of interest for the commission. We passed rules, and then there were more rules passed. I think, or I forget when the rules came in. But I mean, I think the advice I had been giving people for the longest time, there had been some cases we brought. Let me just start there. And the cases were from some pretty egregious facts, and boards weren't getting enough. There weren't good enough procedures and processes, I would say, right? And so I think the way this worked is we passed some rules, and then Chair Gensler passed some more, right? But I think that if you go to corporate America now, they're all over it, right? I speak to a lot of boards. They are front and center on this. Some of the cases that happened, one really comes to mind where there was a breach. The tech people knew about it. The board didn't know about it. And it was a material breach. And if it involves social security numbers, it's material to the SEC. But it is, right? Full stop, right? And so there were people's social numbers involved. And I forget how many, but whatever it is, there's one, it'd still be material. But I mean, there was a lot more than that. So this was a material breach. The board doesn't hear about it, and they open up the trading window still, and all these executives trade. And this information never gets out, and finally they trade at a nice high price, and then the information comes out and the stock goes crazy down. You can see how ugly that is, right? So I think it was SolarWinds maybe. Anyway, so there was all this, all these fines levied and everything else, really ugly. That's not happening anymore, right? Boards now are all over it. There's every quarter, there's the head of the tech group is in touch with someone from audit or one of the other groups, basically at every board, every public company board, saying, tell me what's happening. Are there any breaches? I want to hear about the breaches, right? So there's great communication now. It was really pretty well done that it got out there. And there were some more things that happened under Chair Gensler. And I think one of the things is, I think people, where the SEC would be accused of kind of Monday morning quarterbacking a little bit, because I think there was some sense that nowadays under the new rules, the board has to make a disclosure when there's, quote, a material breach. And the advice I used to give to people was, you'll make a good faith determination and it won't be second guessed by the SEC. Just have good support for it, everything else. And I think I was told that was no longer true because people thought that there weren't enough disclosures happening. People were all taking the position that it was immaterial, and they wanted to get a different message out there to people. So some cases were brought in November. I think if you read them and you read Commissioner Purse's dissent, she would say, you're Monday morning quarterbacking to send a message. This isn't what you're supposed to be doing as to the materiality decisions. So I don't think you'll see that happen again. If the board makes a determination and they have good processes, a good information, a good record, I think they're going to be okay. That's what I'm telling boards. But boards are all over this. So I think in reality, I think it's been an area that is still a focus. If you read risk factors in a prospectus, there's always tons of disclosure about cyber risk and all the rest, privacy rights, everything. And if you blow it and you mess up, there's going to be class actions. You're going to hear from the state people. You're going to hear from the SEC. There's going to be investigations. It's still a huge deal if there's a breach. But I think the boards are all over it. Doesn't mean you're not going to pay lots of money if there is a breach, because you are, if there's a breach of social numbers and things like that. But I do think, the SEC is positioned this well where corporate America is really attuned to this. Doesn't mean it's going to stop, because stopping breaches is really hard.
It's like stopping fraud. It's not going to happen.
Right.
Um, Anything else we should talk about from your time as general counsel? For example, how did you feel that the general counsel office worked? Was it arranged, set up great? Were there things that maybe you would have changed?
Change is always hard, right? I mean, I think, there's a structure and there's so many senior and junior and everything. There's always some people I thought were fantastic and I would have liked to have been able to give them promotions, and it's hard to do it, right? And it's not a promotion. We all make the same, basically. So, it's not going to be monetary. It's going to be a title. People do it for their love of the institution because it's a good place to work. They like the work, but they take a lot of pride in the title. So I would have liked to have been able to give some more titles out to people. Wasn't able to do it. I think in general, I think OGC is fantastic. I think it's really effective. I think the more it's involved in everything that's going on, the better the commission operates. And I think it was probably as involved with everyone else as much when I was there as it's ever been, and maybe ever will be. I think it was a great time to be at the SEC. I think Jay he just hired a bunch of people in senior management who cared about individual investors and cared about the country. And, I think if you look to see who was a Democrat, who was a Republican, it's going to be very mixed. It didn't matter, right? Just a bunch of people who cared. And I don't think that was true of the last administration. I don't think it's going to be true of this administration, right? So I don't know that that's going to happen again. But it was a great time to be there. A bunch of people who really cared about the institution, who cared about the mission. I thought the SEC was fantastic. I really thought the employees were really fantastic. I really enjoyed the job. I had a great experience. Really proud of it and really loved the place.
Terrific. And then you went back to Wilkie after that, right?
I did.
Okay. Did your practice change? I would assume that you a little
Yeah.
more high profile.
When you do a job like this, my wife's up in New York, right? So you have to be away from her. And Jay has kids up here. And so he's away from his family every week. For 4 years, we commute every week and stay down there together and then come back on Friday and then do it again for 4 years, right? So it's a lot, right? And you miss 4 years of your kid's life, right? Which is a lot. I'm away from my wife. Another thing that happens is all your clients go somewhere else, right? And so whether it's in the firm, whether it's to a different firm, and so it's challenging, from a client perspective, because all these clients you built up for 20, 30 years, right, are now with someone else. Right? So that's challenging. You're doing, everyone assumes now you're a corporate governance securities law expert, which you may or may not be, but so you can come in and speak to that, and that becomes a bigger part of your practice, right? Everyone is always because most people who are the GC are litigators, and so they can do investigations and all that. That's not what I do. I mean, I can do investigations, but I don't litigate cases. So I'm not going to do that. I do deals, and so I have to get new clients and new deals and everything else. So it's a little different, a little challenging, but was it worth doing? Absolutely. I speak to boards a lot. I speak to conferences. I speak a lot. I write a lot. So it's been good.
I've noticed that, and it's interesting. You made some public statements, or well, in the journals and things, about some of the things that the next commission was involved in: climate, crypto, that kind of thing.
Yeah.
Was that just a natural thing to do, or did you think real hard before you kind of put those?
Well, I mean, I don't mind giving people my view, right? And I think I'm on former Commissioner Jackson's board at NYU. And I told him after the West Virginia EPA case came down, I said, this there's no way that the climate rule is going to survive. And I ended up testifying about it later in front of the House Financial Services Committee. And I said, my view as a lawyer, right, not is I don't see how it survives, and it also might fail since we're already requiring all the material information anyway, even before the rule comes in. There's kind of a cost benefit analysis at some point that kicks in under the APA, and there's a lot of cost, and I don't know how much benefit since all the material information is already required. But okay, so I thought it was a mistake for the SEC to go down this road. I can only imagine how many hours it took for my former office to write it. I didn't think it was a worthwhile endeavor. People have different views about this, and Commissioner Jackson said, "You're wrong. It's going to survive." And I said, "Okay, we're going to bet $5, and I'm going to win." And I don't know that I am going to win because, well, I still might win because it's in a circuit that will probably knock it down. The Supreme Court would definitely knock it down. The SEC stopped defending it, but that doesn't mean it's not going to go forward. I don't know that it's going to go forward. There's a lot of state AGs involved, right? And they can pick up the case if they want, right, and go forward with it. And would the SEC come back on the other side? I don't know. But there's state AGs on both sides. So it becomes like a political analysis because if it gets knocked out, you'll never see it again, right? But if it doesn't, right, and they just do a new economic analysis, which is what they would do otherwise, and come to a different rule conclusion and obviate the rule, it might come back again, right? So what do you do from a court perspective if you're, I don't know. I don't know how this is going to play out, but it'll be interesting. So, but speaking about it, I was happy to give my views about it. I didn't like that it happened. There's some things that we all have views, right? I mean, those are just my views on this. I still think it's a great place. I just didn't agree with the decision. But from like when I testified, I told Michael, I got up there and I said, listen, I don't blame the staff. They do what they're told, and they will. This is the ping pong ball, right? And this is how it's at the moment, and they were told to do it, and they did it, right? Okay, I didn't like the decision from management, but I thought the staff's perspective, it's I don't blame them for one bit.
Anything else that we should discuss that we haven't?
Not really. I think the big point was OGC, the importance of OGC being in everything, being the general counsel of the SEC is an amazing job, and the quality of the people are fantastic. I think the more involved they are in the building, the better the building runs. And I just think the SEC has a very important mission for the country. I think we're pretty lean. I know everyone's concerned about leanness these days. We're 4,500 people. I think it'll get smaller, but they do a lot. They punch above their weight. I do think that having them back in the building is good. I think that will be good. I don't know that they need a new building. I don't think they do. I think that current space is fine. And I like the fact that they're close to Congress, and not out somewhere like the FBI is or something in the suburbs. I think the building's going to be fine. I think Paul's going to do a good job, and it's a great place.
Well, great. Thank you for talking to me today. It's been a lot of fun, and I've learned a lot.
Thank you, Ken. Nice to be with you.